would like to say a very warm welcome on behalf of the South African Board for Sheriffs to all of you who have logged into this masterclass today. It is indeed a pleasure to share a few words at this event, the last masterclass for this financial year. The theme of this masterclass is aptly described as maximizing your income, and I'm sure that's why we have so many participants logged in today. This masterclass is the culmination of a series of virtual financial classes that we've had over the past few months. Let me say a few words about the challenges of education and training that we've been facing, as this masterclass is indeed part of a broad framework of education and the application of modern technology. According to UNICEF, when the pandemic hit, apparently 91% of the world's enrolled students were affected when schools across the continent closed down to help spread the end of the coronavirus. Governments and stakeholders combined in the education sector have been actively engaging in discovering ways to implement remote working learning methodologies to ensure that children and other learners continue to get their education even if they are confined to their home. What does this mean for the South African Board for Sheriffs? Well, as a board, we've continued to meet the demands of the training portfolio that is required within the South African Board, and further success engaging with our sheriffs in the online virtual environment. I would like to share with you our program for today. Let me start by saying that our moderator is going to be Mr. Alan Murrigan. He's the chairperson of the training committee for the South African Board for Sheriffs. From the court services, we have Mr. Timalema, the regional head in Gauteng. Joining us from the small claims court is Mr. Sifutain. He is the acting area court manager. From the CCMA, we have Mr. Manshule, who is going to be assisting us with that discussion. He is a senior commissioner at the CCMA. The state attorney has borrowed us Mr. Chawe for the day, so we can tap into his knowledge around the state attorney. And then from the taxing master's office, we have V. Pillay joining us. And finally, closing the session today is Ms. Ralishlake. She is a board member from the South African Board for Sheriffs. But before we start with the planned session, I would like to introduce the chairperson of the South African Board for Sheriffs, Mrs. Charmaine Mabuza. She is the acting sheriff in Mpumalanga and has guided the board for a number of years now. We are privileged to have her as our chairperson since she brings with her a wealth of experience and knowledge and has many, many achievements. Let me mention a few of these. Mrs. Mabuza is the CEO and co-founder of Ituba, South Africa's lottery operation, the co-founder of the Eric and Charmaine Mabuza Scholarship Foundation. She was also one of the founders of Zamani Holdings, a holding company for various independent companies. She has served as a trustee for the UNISA Foundation. She has served as the deputy chair for the University of Mpumalanga, and she also chairs the nomination committee. Further to this, she serves on the NEEC committees, and she has spearheaded transformation within the judiciary. Mrs. Mabuza is a business entrepreneur with extensive business and operational management experience. She serves on a number of boards, including Whiphold, the first female-owned company to be listed on the JSE. Need I say more? Please join me in welcoming Mrs. Charmaine Mabuza.
Good morning, and thank you, Jody, for that kind introduction. Let me start by saying on behalf of the South African Board for Sheriffs, a very good morning to my fellow board members who are present here today, sheriffs and their staff from the various parts of the country. I know that the weather has been so kind and it's raining, you could be in bed, all of you. Staff of the board, thank you for being here. And most importantly, our esteemed panelists, thank you for taking the time to come and share your knowledge with us today. I'm happy that the number of attendees have grown with each of these sessions. This tells me that the profession has realized the importance of continuing to learn and engage all aspects of our duties. I was pretty surprised. The combined total of participants for the past 3 masterclasses have exceeded well over 300. Thank you for participating all the time. Ladies and gentlemen, the world has been confronted and tested deeply by the wave of disruption caused by the COVID-19 and the most epic public health crisis in modern history facing the world and South Africa. Not a single country was adequately prepared to mitigate this pandemic. In fact, on the global front, we noticed that the absence of contingency plans to weather this storm and crisis. On the business front, disaster recovery plans were tested and found wanting. Having noted this, we as a board can confidently state that our house is standing strong on its foundation despite the deep challenges we are facing. As we look forward to 2021, the reality is that we do not have a choice but to forge ahead with our planned objectives that we have set ourselves. We cannot make this pandemic an excuse to be able to deliver on our mandate. As the South African Board for Sheriffs, we need to execute plans to achieve our objectives and discharge our responsibility with precision, like we have done in the past. However, the challenge is to adopt our plans in anticipation to combating the challenges we face. The same can be said for sheriffs in their respective offices and our stakeholders alike. We all face challenges. For these reasons, we have invited a panel of stakeholders that we as sheriffs depend upon for our income. They in turn require the best quality service from us as sheriffs. Let us trust that through the discussions we envisage today, we will be able to understand each other's needs better and that we will forge greater working relationships. The purpose of the financial masterclasses that we have had to date was to ensure that sheriffs run their accounting books in systemized ways, that the correct application for tariffs are applied, which is often a problem if you look at the complaints that come to our office, that we are making use of appropriate software management systems and ensuring that appropriate data management systems are in place, and that in turn will ensure that sheriffs have control over their cash flow, business accounts and trust accounts. As you know, cash flow has become a big issue these days due to the non-payment of our accounts. Thus, the purpose of the masterclasses to maximize your income has a similar goal. Through the engagement with our panelists, sheriffs will have a deeper understanding in respect of the processes and procedures to access payment of their invoices for services. Honestly, whenever I go to any of these consultative forum meetings or meetings, this is the biggest complaints that sheriffs have, that our invoices are not being paid by our statutory partners. And fortunately, we have them here today to engage them and understand what their needs are in order for us to follow the processes and each step so that we don't miss it by the way. Embedded in this educational collaborative session will also be the engagement of practical issues experienced by sheriffs in their struggle with payment processes. Let me close by saying that the disruption caused by the pandemic requires a vigorous response to creating the new norm. Now everybody's talking about the new norm. Virtual and services of documents electronically is soon coming our way. We need a response that the professionals, the sheriff's professions, that it is characterized by innovation, creativity, agility, and reimagining to ensure a future for this profession. On this note, I'd like to take this opportunity to thank the panelists that I present here today. I will not name you one by one, but I really would like I'd like to thank you for taking the time to join us. The training committee led by the chairperson, Mr. Erlen Morgan, who's present here today. The staff of the board led by Ms. Jody van Wyk, who just spoke before me, and Mr. Nel, who is at the head of the training, and the entire staff at the board. This has been, and of course, the service providers who have partnered with us here. It has been a wonderful experience, and I think we've really gained a lot of insight and unearthed matters that are of importance to us as professionals in this regard. I'm confident that you'll enjoy this masterclass. I now wish to call upon my fellow board member and colleague who actually chairs the training committee, Mr. Alan Morgan. Mr. Morgan has been extremely instrumental in designing some of these modules that we've seen during the master classes, and who will be moderating this session for us. I thank you, Mr. Morgan, you and the committee, for the hard work that you've put in for us to have these successful master classes. He's a practicing sheriff in KZN, and a very experienced one at that, and very passionate about this, and an executive member of the board. I thank you, Mr. Morgan, and once again for moderating on our behalf, and I'm sure you'll be able to handle it. And to you, the participants, I hope you have found great value in these master classes. I think they've just been on top of the issues, and I hope you enjoy today and enjoy your rainy weekend. Thank you.
Thank you, Chair. Thank you, Chair. And good morning, Mrs. Mabuza, the Chairperson of the South African Board for Sheriffs, the Executive Manager, Jody van Beek, honored panel members from the various departments, management, sheriffs, deputy sheriffs, and office staff. Thank you, Jody, for the good, beautiful introduction. Colleagues, I will get straight to the program of the day. As Chair pointed out, we have some very esteemed professionals from the various state departments to address us today. I would like to just call upon our participants to feel free to forward questions and or suggestions via the chat group that is linked on the Zoom link. Due to us trying to ensure continuous connectivity, you will not be able to ask questions live, but you are most welcome to forward your questions via the chat group. As we have 5 speakers today, colleagues, I would like to recommend that you forward your questions on time to be posed to the relevant speaker immediately after he or she has completed his presentation. Due to the time allocated to each speaker, they might not have the opportunity to answer your question at a later stage. If we have too many questions that cannot be answered today, we will most certainly respond to you after the program. Colleagues, the board is engaged, as I said, very crucial representatives from the various state departments, who we thought would play a role in assisting you in maximizing your income in these difficult times. I'm immediately now going to hand you over to Mr. Malema, the Regional Head of Justice for Gauteng, who will be representing the court services today. Colleagues, very quickly, the reason Mr. Malema is here is to assist us as sheriffs, enlighten us about various court services that his department is responsible for. Over and above that, colleagues, we're hoping to hear some good news from Mr. Malema on the various ways that his department can assist us sheriffs. Mr. Malema, over to you, sir.
Thank you very much. So I'd look at what I call a strategic engagement between ourselves and the sheriffs. So yeah, that is the table of contents. What we can do in terms of outreach, look at issues around jurisdiction, the challenges with sheriffs and training, and stakeholders, and the issues raised around the service of process by the maintenance investigators. I think as a starting point, the relationship between ourselves and the sheriffs, it's what I can describe as a strategic partnership. Therefore, it requires that we work together. So it is my submission that I think we could work better if, for example, the sheriffs in the different regions participate in the strategic planning sessions of the department. When I was the regional head in the Northwest, we used to invite a representative for the sheriffs in the province, who would actually come and take part and present around the challenges that the sheriffs encounter. But they would also understand the strategic goals that the department also seeks to achieve. For example, we have as one of the strategic goals and a KPI for vulnerable people on maintenance that requires that the sheriff serves and give us a return. And as soon as that return is filed back with the court, that return, we start counting 90 days. The court has 90 days from which it then can finalize the matter. So it's therefore very important that the sheriffs understand this. But secondly, I would look at aspects like probably an MOU, which I think should be explored between the department and maybe the board, broadly for the sheriffs, around, the return of service, the issuing, so that there are some systems that we have put into place that we use to hold each other accountable that within a particular period, the clerk of the courts will do the following, but in return, within a particular period, the sheriffs will, in terms of the service, they will bring back the service by a particular period. So that's part one of the suggestion, which at a strategic level between the department and the board could be explored. The second aspect that I thought we should explore is relating to community outreach and communications. Prior to the pandemic setting foot upon us, as a department, we used to collaborate with the sheriffs. We would invite them when we would go out and engage members of the public in terms of speaking to them about the various services that the department has, hearing about the challenges that they have, would actually allow the sheriffs to do that. I think this is very important because, you still have in some communities where the perception of the public towards the sheriffs, it's not a very positive one. So we believe that by participating in outreach programs, which must obviously at this stage take a different turn because we're not allowed to, have mass meetings. But there are radio platforms. We continue to have those radio platforms in the department where various technical people address various issues, let's say on maintenance, on domestic violence, on small claims court. We use various platforms like TV, radio, social media. So it is my submission that if the sheriffs, either through the board or through the department itself, we can accommodate them. They can field a person that can speak on this aspect. Because once we have cleaned up this perception, when the sheriff then has to perform their functions within communities, then they will not meet a very hostile, members of the public. So we believe that public education and communication is very, very important. As part of also trying to enhance the work of the sheriffs, you're aware that the Deputy Minister, John Jeffrey, together with our DDG Court Services Advocates Kosana, they have been leading a project on the rationalization of the magisterial districts. And this has also included the sheriffs, in which we have tried to align, the sheriff's area of jurisdiction with the magisterial districts. There's a few areas where we've not been able to finalize those areas, but the work continues. It's largely around areas where there are some challenges in respect of communities. But in smaller jurisdictions, the department has gone out of its way and have asked that some areas could be combined, so that one sheriff serves more than one area of jurisdiction. I recall in the Northwest, we did that quite a lot because it is not in the interest of the department to see a sheriff going under, because there is court process that needs to be served. Further to that, the department has also taken the view that it is better to appoint a single sheriff for both the High Court and the lower court in the same jurisdiction. So all of these are intended to make the work and the profession economically sustainable. I can also report that we have commenced with the process to fill in the current vacancies in the various regions. Most of the regions have started. Some are about to conclude. We are hopeful that by the end of this year, we will finalize those appointments, and the new sheriffs can then commence. There is also an issue around tariffs of fees and invoices. The chairperson of the board earlier on, Mr. Mabuza, referred to that. This is a very critical issue. So from our side, we are in liaison with the Justice College that does the training. We have two forms of training. We have basic training. We also have advanced training on taxation. but we also have training on civil for the clerks. So we will make sure that we liaise with the college to ensure that you know, that training takes place. But to come back to the tariffs, we'll ensure that the clerks are actually taken through the process on the fees or the tariffs, so that they understand, so that we avoid disputes when bills have to be taxed, and that they're taxed properly. We are also, Chair, busy with the process to ensure that we pay all service providers, including the sheriffs, within 30 days, because if we don't do that, you know, we may make some businesses to fail. But it's also important that, you know, we've picked up that there are still issues with tax clearance certificates from some sheriffs. As a department, we are required in terms of the treasury regulations that you know, sheriffs should have tax clearance certificates that are in order, so that we can pay them. But also that the bookkeeping must be done. There's some issues that some of the courts have raised around double billing, because you know, there is no proper accounting. But this also applies, Chairperson, to the department. So it's not only a problem on the side of some sheriffs, there's also a similar problem that we encounter on the side of the courts, where payments are, it's one bulk amount there that's not broken down. So we have urged the courts that, look, although you're paying one sheriff a particular amount that is, you know, aggregated, please have a spreadsheet that actually shows, you know, that X amount is for a particular invoice, X amount is for a particular invoice, but at the same time, the sheriff needs to be done. I recall when I was in the Northwest, we had a similar problem in Rustenburg with Mr. Dawu, who's still a sheriff there. We worked very well. We met, and we, as the regional office, together with the court, to actually do the reconciliation. So I strongly urge that you know, the sheriffs should feel comfortable to approach the court manager in their area of jurisdiction, or if they cannot find joy, to actually approach the director of court operations or the regional head in the regional office to actually resolve these issues. I think I've earlier on referred to training, because we believe that training is very important. We are a learning organization, and any learning organization, just like yourselves as the sheriffs, through this masterclass, training has become an ongoing part of your life. So I've referred to the training programs, the basics and advanced on taxation, as well as the modules on civil. But Chair, I'd also urge that where possible, it would be great that you know, we allow some of the sheriffs to participate in the training, the experienced ones, just to give the practical side of, you know, what happens in real life as a sheriff when such training happens. And this can be arranged through the DDG Court Services Advocates Kosana, who can liaise with the acting head of the Justice College. I'm certain that you know, this collaboration can enable us, you know, to deliver better. And on the IT side, we've also made sure that IT is a key pillar of one of our strategic goals. For example, we are busy upgrading our video conferences in the different regions, you know, doing procurement on laptops, desktop, PBX, you know, so that as a department, as the president has said, we need to be riding the wave and be part of the fourth industrial revolution. You know, from the side of changing the laws, the rules board, I'm certain will also be tasked with the function of actually examining, you know, processes that needs to be, you know, laws and rules and regulations that needs to be changed to actually enable the department to function on virtual platforms. As I come towards the conclusion, I also believe that it's important that the sheriffs as stakeholders in the courts participate in the case flow management fora that exist in the different courts. I know this might take time, but it's a very important a platform where at a district level, you know, the sheriffs can participate, you know, to raise issues where they have challenges, and not just with the clerks, but maybe, you know, with the magistrates, with the prosecutors, so the police, everybody sits in there. So I think You'll find the DECs, which are the district efficiency led by the chief magistrate. And then at the regional court level, we have the REEC. And then at the provincial level, we have the JPs that are leading the PEC. And right at the top, you then have the NEEC, which is led by the Chief Justice. All of these structures were created by the Chief Justice to enable, the various stakeholders within the court environment to be able to talk to each other. So it's very important, therefore, that the sheriffs are then aware and they can participate in these various forums and they can raise their issues. And finally, I'd like to address the issue that was raised around the service of process by the maintenance officers, specifically on maintenance matters. Chairperson, you'll appreciate that for us, maintenance is a very key area that delivers services directly to the public. So that would be maintenance and domestic violence. But specifically with maintenance, the law was designed in such a way that it takes into account that there are vulnerable people, women, that are trying to get money to raise their children by asking a court to issue a maintenance order. And that's why the system was even designed to actually provide for a maintenance officer who is almost like a lawyer for the child, so that the best interest of the children can be brought before the court. But when it comes to the service, the maintenance investigator then performs that function. You'll appreciate, and I know that some sheriffs might feel that this, it takes a bit on their income, but these are vulnerable people, and I don't think we should be wanting to make a financial gain, on poor people who are chasing very, very little amounts in most instances. And so that's the reason why this practice will continue. It's strongly supported by the department, as well as the judiciary and the prosecution, because it does relieve, the burden on maintenance applicants. Would actually urge that would appreciate it as a gesture of goodwill. If we could see, I know some sheriffs are already doing that, who are willing to provide pro bono services on maintenance for the applicants. I would conclude by saying, Chair, that in the current stage of gender-based violence that we're experiencing and what the President launched yesterday, the fund, I think it would also be a good gesture if we could, where possible, see some sheriffs also willing to assist in the service for the domestic violence interim orders and final orders. Many women have been killed when they went there to serve on their own. Currently, we're using the police. Sometimes we have delays. It would be appreciated if the sheriffs could participate in this. So those are the few issues that I thought we could share with the panel and the participants around, the ways and means that we could be looking, to ensure that we can improve on the services and we can support the profession so that it becomes viable and it can thrive. Thank you very much.
Thank you, Mr. Malema, for the very informative talk. I have a few questions from you. As you should know, the sheriff's profession is a very dynamic profession, a very unique one at that. So we have a number of sheriffs who've been posing questions to you, and I'm just going to read out a few. I hear you very loud and clear about the maintenance court matters and the availability of sheriffs assisting in that area. But Mr. Malema, as you understand and as you pointed out that you are aware of the sheriff's plight as well in terms of financial viability, and it is for that reason sheriffs in the more rural towns have difficulty in being sustainable and really depend on maintenance court work. So I have a plea from Mr. Titus Robertson from Zanin and Mr. Mapufu from Limpopo, who calls upon you to try and assist in ensuring that they get the maintenance court work to serve. That would help them. As you know, the rural town sheriffs, Mr. Malema, really depend on every single document that enters the office. So that's a plea to you to see how you can assist the rural towns, Limpopo, in particular, I see, and Eastern Cape, in getting the maintenance court work through these sheriffs. Mrs. Teresa Withers has posed a suggestion rather than a question, and asking if you could assist in ensuring that the reconciliation of the statements and payments is looked into. As you know, Sheriff serves documents for various state departments, Mr. Malema, and the Treasury Department would obviously make payment as they receive the statements from the sheriffs. And when payment is made to the sheriff, you get one singular amount coming into the sheriff's business account, which is, and without a breakdown of those payments, it is impossible for the sheriff to distribute that money to the various departments that he's done work for. So getting the disbursement numbers and the breakdowns would assist the sheriffs in speeding up the process of reconciling the statements, and obviously getting the income into the business. I don't know whether you want to take the opportunity to answer those questions now, Mr. Malema.
Yes, Chair. I can deal with the questions. I've already referred to some of those questions. Look, I do sympathize with the sheriffs in small rural towns, but that is also the area where poverty is grinding. So if you look at Limpopo, you know, Eastern Cape, those are really the poor areas. So it would be very difficult, I must say. But it's something that I will put to the department, you know, to expect the women to pay. We've seen this as well, you know. I'm sure the colleague will speak to the small claims court, will refer to that. Because the idea of small claims court is also to make it easier for people to access justice. But, you know, you have other issues, you know, around service and all that. The second part, the recons, as I said, again, this is very important for both the sheriff and the courts. We'll see. I had wanted to suggest that perhaps the board should be also discussing with the department around how they can integrate software, you know, for invoices, because the current system is very manual and very cumbersome, and those are things that create delays. You know, double billing, invoices lost. So if we could find a way that we speak to each other and we integrate our systems, you know, for submissions of payments online, as well as the payments, I think it's possible in the current age. As opposed to submitting, you know, a hard copy document, and I think that might assist us. Thanks, Chair.
Thank you, Mr. Malema. I have another question, or a suggestion rather, from Mr. Nkomisi, the Sheriff of Paarl, and a board member, who wants to highlight the concern about taxations of sheriff's invoices. He says that there is doubt as to whether the taxing masters have proper knowledge of the sheriff's fees in the various courts that they serve, and believe that more needs to be done in terms of assisting the taxing masters understand how sheriff's billing operates, and obviously to be fair in the taxing process. I'm going to give you another question, a problem rather, from Machuari, who's wanting your assistance in engaging the police minister or the police department in ensuring that the deputy sheriffs and sheriffs receive police assistance when they need it. He believes that this assistance will help him execute his duties much more professionally. Over to you, Mr. Malema.
Thanks again, Chairperson. I'll start, you know, with the last one. As part of the stakeholder collaboration that I have mentioned, the police also sit in the various case management committees that I have mentioned. At every court, we have the police that are part of case flow management. In every province, through the the forum led by the judge presidents, the PEC, the police are also sitting in there. So I do think that, Chair, that the sheriffs must participate in the fora that are available. There's many avenues through which we all deal with these challenges, because the system within which we work is a complex and integrated system that has a lot of dependencies. There's no one that can work on their own. So I would strongly urge, because it's not all in all areas. I've mentioned that there are areas where the communities are hostile towards the sheriffs. So if the sheriffs were taking part at a local level, at a district level, at a provincial level, within case flow, and the police in different ranks also sit in those fora, they would be able to articulate the issue. And I'm sure the police, as they do, they would be willing to assist there. Yeah, on the taxation, I think I've already referred that we will liaise with Justice College to assist the clerks with training ongoing, so that they do not give a hassle when they must actually tax correctly and then effect payments. Thank you.
Thank you, Mr. Malema. One other question. Well, as we just answered we answered the last one on maintenance court work, but just to let you know the plight of sheriffs, I've received one from the Eastern Cape as well, Mr. Ricard, who pleads to you for maintenance court work, and obviously calling on you to see how you can assist them. Mr. Malema, Mr. Nkomisi also talks about the case flow management meetings, which is, we believe, a very important link between the sheriff's profession and the courts. But there seems to be a break in communication between the judiciary and the sheriff's profession in terms of the invites. And we believe as the board that every sheriff should attend his case flow management meeting within his magisterial district. So if you can escalate this matter within your departments and the various courts in ensuring that sheriffs are invited to these meetings, that will further enhance the communication gap, or improve the communication gap between the profession and the courts. That will be of great assistance. Further to that, Mr. Malema, when we were putting this program together, one of the thoughts behind calling somebody from court services is trying to address you on, as you know, the theme of our masterclass today is maximizing your income. And as you know, sheriff's profession is largely based on ensuring that documents enters his office so that they can serve these documents and generate a turnover. We understand that COVID-19 has impacted on all businesses, but we just want to bring to your attention or plead to you to ensure that clerks of the courts issues documents as fast as possible, so that those documents can in turn be forwarded to the sheriff as fast as possible. We find in many courts work lying in bundles at the various magistrates' courts, waiting to be issued. And this creates a problem for sheriffs in terms of receiving the work as fast as possible, and obviously keeping the cash flow moving in his office. If you can assist us in some way or the other in communicating this message to the various clerks of the courts, and obviously highlighting to them the importance of that work leaving the clerk of the court and reaching the office of the sheriff. I have one more question here. Mr. Ian Burton, please provide some clarity on taxation. Well, you answered that question now. We will take you up on the offer of training, and obviously participate so that we can highlight to the taxing masters what they should be looking out for when taxing sheriff's bills. The other query that Mr. Ian Burton has raised, which has been a recent amendment to the Magistrates Court Act, wherein the amendment now requires that the taxation takes place at the court who first issued the document. The document, and this creates a problem for sheriffs, Mr. Malema, in that sheriffs now have to travel to a court outside his jurisdiction or outside his province if the summons was sent from another province. So it is creating a financial difficulty for sheriffs to go out there and obviously fight for the right in terms of his invoices. So we would like for you to address this issue as well. Mr. Richard, He wants to know, is it possible in the future that a taxing master could attend a sheriff's training program and explain how taxing of bills are done? As you can see, there's a number of queries in regards to taxations. If you could look at that. That's all I have for you from the profession thus far. But there is a few points that you raised, which is very important. And as the board, we will revert to you, especially in terms of training and in terms of the taxing of sheriff's bills. Thank you. Over to you, Mr. Malema.
Thanks very much, Chairperson. I'll just deal with the ones that I haven't answered. First, let me appreciate the acceptance of the offer by some of the sheriffs to assist us with training from a practical point of view. I think that would help. So we will certainly prioritize the issue around training. I did refer to it in my presentation because this is a bone of contention. It delays and affects the business of the sheriffs. I had also suggested that we should be looking into either an MOU or we create a key performance area with the board and the sheriffs around the turnaround times, for both when there is service for the issuing by the clerks and the returns by the sheriffs, because it cuts both ways. I think it would actually, facilitate service delivery for all. So it's something that I think we should explore with the board in terms of creating an MOU. The training I think we've referred to. Look, I think as regards the amendments, I would suggest that we will take up the issue, but I think the board should probably write to the DM around this matter. I'm not sure really what informed the rules board when these changes were made. But I'll take up that with Advocate Skosana and our rep in the board. I think it's Mr. Isaacs, if I'm still correct, to see the board can review this. But I think it would help if at the board level for the sheriffs the matter can be brought to the attention of the deputy minister in terms of the difficulties that it is creating for the sheriffs. Thank you very much, Chair.
Mr. Malema, on behalf of the board and the profession, we want to thank you for attending this masterclass. Your PowerPoint presentation was very informative, and we're looking forward to further engagement with you, sir, and your department. Thank you very much. Colleagues, ladies and gentlemen, we're now going to move on to a presentation from our colleague at the Small Claims Court, the Acting Area Court Manager, Mr. Fontaine. Mr. Fontaine. Mr. Fontaine will do a PowerPoint presentation for us on the process followed at the Small Claims Court. As you know, the Small Claims Court is a very important stakeholder in the civil justice system, and obviously a very important role player in the sheriff's profession. I'm now going to hand you over to Mr. Fontaine, who will do a PowerPoint presentation, and thereafter I will take questions and or suggestions from the floor. Thank you very much, Mr. Fontaine. Over to you.
Good morning, everyone. Thank you very much for the opportunity to address you on the small claims. I'm just going to share the presentation. Yes, good morning. The Small Claims Court, as an advisory board, it's Small Claim Court, and the advisory board is active. The advisory board normally consists of the senior magistrate at the court, the court manager, and one of the commissioners. The advisory board meets once every 3 months or 6 months, depending on the activities happening at the Small Claims Court. There's also a dedicated clerk that is responsible for processing of all documentation at the Small Claims Court. The clerk is also responsible for determining the dates of appearances. Now, what normally happens at the Small Claims Court is the clerk would draw up a program for a period of 6 months in the future. That program is then shared with the advisory board and sent through to the commissioners that are active within the specific court. The dates in the future is normally 1 calendar month after the summons have been issued, but it also depends on the court role. Taking into consideration that some courts would schedule cases, 5 cases per sitting due to the lack of active presiding officers. The presiding officers are commissioners that have been appointed by the Minister to preside over the small claims matters. Amendments and return of services. All amendments emanate from court, and revised documents is normally handed to the applicants for submission to the sheriff. If the return of service is not available on the court date, the matter will be postponed or the matter will be struck off the court roll. Therefore, it is important to ensure that submission of return of services is important. In some areas, plaintiffs are requested to collect the return of services on their own, while in other areas, the return of service is delivered to the court as part of the normal process. That is prescribed in terms of the code clerk of the small claims court. So the two ways of operation is not wrong. It can either be the one or the other for that matter. If the return of the faster the return of services reaches the court, the faster payments can also be done, and that relates to the other civil processes. The challenges that we experience within the small claims is that meetings, Mr. Malema alluded to this, that there need to be more participation at the different forums. The meetings with small claims staff and the sheriff is not happening, as well as meetings with the advisory board and the sheriff. Case flow meetings. In terms of our deferred fines, which is not part of small claims, we found that the sheriffs do not want to arrest people for deferred fines because there's an argument, it's a criminal matter and sheriffs must do the arrest. That's also a way of generating income for the sheriff as such. But what comes out of all this is that I saw one of the questions is, should we not have virtual meetings? And yes, it is true since the start of the pandemic, the case flow meetings have not been happening. The new norm is what we are doing now, virtual meetings. Mr. Malema has alluded to the infrastructure that is required, which is your PCs and your connectivity as such, and that is something that we need to consider at court level. So the solutions, we need to invite the sheriff to the advisory board meetings as well as case flow meetings, and we need to open the channel of communication between the sheriff and the court staff at the small claims in general. On that note, thank you very much.
Thank you, Mr. Malema, for that. Thank you for that, Mr. Malema. Yes, as I mentioned at the outset, that small claims court matters is very important to the sheriff's profession. I have one question here from Ms. Teresa Withers, rather a remark, stating that she is the sheriff of Bellville in Western Cape, where she states that she has never been invited to a small claims court case flow management meeting in Bellville. So it's something that if you could take up with your department. I have a few more suggestions on the case flow management meetings from Mr. Naidu, the sheriff of Mayerton in Joburg. Also querying the issue of the case flow management meetings wherein sheriffs are not invited to these meetings. So if I'm sure Mr. Malema is online still as well, I impress upon you to ensure that sheriffs are invited to these meetings. I do not have any further questions on small claims court from colleagues on the ground. All right, for Mr. Fortune, just one remark. We obviously serving small claims court summonses, and one general difficulty that sheriffs experience, especially now with COVID-19, is the short time span that the court gives the sheriffs to serve these documents. And as you know, being small claims court matters, we obviously depend on the plaintiffs providing the information to the sheriff or to the courts. And generally the addresses are not correctly cited on these summonses. So if you could ensure that your clerks in the small claims court try and get as much information for us to assist the plaintiffs so that we can assist them in serving those documents timeously. As you know, it requires 10 clear court days to serve these documents. We have another question from Bronwyn. She's also talking about the dates after the date of issue of the summons to the small claims court. We have brought this to the attention of the court manager. They need to allow at least 15 to 20 days before the date of issue of the summons for the trial. So that's one of the suggestions, Mr. Fortune. Mr. Nkomisi, is it critical to be used in order to ensure that the plaintiff and execution debtor get value for the money the sheriff provide? Make sure that the defendant and the execution debtor is not a man of straw. It's frustrating when we have to issue a nulla bona return because the debtor has no assets. So Mr. Nkomisi has that frustration in asking you to ensure that when the matter is being heard and both parties are in court, that proper investigation is done into the possible attachment of the assets. Over to you, Mr. Fortune.
Definitely, what we will do is I will report this to the Director Court Operations. And from our side, we will look at getting the sheriffs on board, number one, and also address the issue of the short time periods with our clerks to make sure that it gives the sheriff enough time to serve those processes. As I indicated in my presentation, normally we arrange for 1 calendar month in advance, but then it is also dependent on the complainant to get to the sheriff in time for the process to be served on the defendant as such. But definitely we take note of that.
Thank you, Mr. Malema. I have a question from Naidu, Sharon Naidu, who says, or rather a suggestion, says that it would be good for your department, your clerks of the courts, to ensure that the plaintiffs understand the procedure that will be followed after the summons has been issued. Generally, we find that the plaintiffs do not understand the next step or the various steps that is followed in the courts and at the sheriff's department. So she is calling on you to ensure that your clerks of the courts explain to people, these plaintiffs, the process. Brandon Swedela, he says he has 5 jurisdictions that he serves, but he has never received a small claims court summons to serve. And on numerous occasions, he has asked the clerks and even the court manager regarding the small claims courts, and the reply remains that the police are serving the small claims court summonses. Unfortunately, I do not have the jurisdiction of Brandon Swedela, but Mr. Fortune, that's from him. Mr. Rishad Singh of Lower Tugela, the process must be explained to the plaintiff when documents are issued as well, similar to Mr. Naidu, wherein he says that the courts must try and assist the plaintiffs in understanding the process followed. Mr. Henrik Tao says, what is the solution in respect of the defendant wants to pay the plaintiff after the attempt of the execution of the warrant and there is no attachable assets? Who is responsible for the arrangement of the part payment? Will it be the clerk of the small claims court? Because the court said it is the responsibility of the sheriff. Please give us clarity. Over to you, Mr. Fortune.
Thank you. The operation of the small claims court is guided by the code clerk of the small claims. And in this code, it states what the responsibilities of the clerk. And one of those responsibilities is to explain to the plaintiff exactly what is required of the plaintiff and what the processes are. At this stage, I think it's important that we need to engage once again with our justice colleagues and arrange training for the clerks dealing with small claims, and most probably also invite the Board of Sheriff to come on board with this training. In terms of dealing with the financial aspects of the small claims, where one party needs to compensate the other party, that will always be an agreement between the two parties. The court is the facilitator. We do not have the functionality to accept any monies from a respondent, for argument's sake, that comes and says, I would like to pay. That is an agreement outside. Our responsibility stops when the court case has been finalized. But the question is valid, and definitely we will have a look at that. The fact that before the process is finalized, the two parties come together and they there is a decision to settle the matter. Someone needs to take responsibility for that costs, wasted costs. And in most cases, it will be at the behest of the plaintiff or defendant. They need to come together. Thank you.
Thank you, Mr. Fortune. These are all the questions that we have for you for today. On behalf of the South African Board for Sheriffs and the sheriff's profession at large, I want to thank you for acceding to our invite to come and chat to us today. It's the first of many more engagements with your department, I must say, and hoping to see you in the near future and obviously try and find solutions to these various suggestions or questions raised today. As I said, on behalf of the board, I want to thank you for your time today. Thank you, sir.
Thank you very much for the invitation. Have a good day.
We are now moving on to Mr. Manshule, the Senior Commissioner at the CCMA. As you know, the sheriff's profession has been engaging the CCMA extensively in the recent years, especially through the amendment of the Labour Court Act that required extensive engagement. We've been, as you know, as a profession, we have not ironed out a number of gray areas. We invited Mr. Manshule to come in and do a presentation and obviously give us more insight as to the progress made within his department in ensuring a smooth flow of the maintenance enforcement, at least the CCMA enforcement awards. I'm now going to hand you over to Mr. Manshule, who will do a PowerPoint presentation as well. Thank you. Mr. Manshule.
All right, thank you, Chair. Our presentation as the CCMA will touch on the following: the role of the CCMA in the enforcement of arbitration awards. We have also attached our information sheet, which acts as a guide in the processes that are being followed, and critical part, especially in relation to what the theme of today's workshop is about. It's important for us as an institution to clarify what we pay for in respect of enforcements, areas of improvement in the relationship between the commission and the profession, the role, or what we see as the role of Legal Aid South Africa in an attempt to assist the process of enforcement. It must be borne in mind that this one is informed by the provisions of Section 149 of the Labour Relations Act, which places a duty on the Commission and Legal Aid South Africa to assist. And then the process of reconciliation and processing of invoices will also be touched on. Just a second. Okay. Our role as the Commission needs to be understood, Chair, from the point of view that we are an administrative tribunal which has quasi-judiciary powers. We are, amongst other things, required to offer assistance to our users, and that assistance is both administrative, and in terms of enforcement, it also goes further to payment. We pay in the process of enforcements for employees who are earning below the threshold Now our threshold stands at 205,433.30 per annum. It's crucial that even if a sheriff is faced with an employee who earns below the threshold, however, the arbitration award that is in a process of being enforced is a bargaining council award, whether in the private sector or public sector, that the commission does not pay for those employees, even though they might be below the earnings threshold as set by the Minister of Employment and Labor in this regard. When we received the Section 43 applications, I will keep on referring to Section 143 because this is the section that empowers us. This is the section through which these enforcement processes are dealt with at the Commission. These are processed in terms of our own standard operating procedures, which require that in relation to CCMA arbitration awards, an LRA form 7.18 would be used by an employee, and this form, upon completion and it having been commissioned, would then be served on the employer. Now, let me hasten to add that the process of service is good practice, in that although there is no absolute requirement that it is done, but it is good practice because it is a process of notifying an employer that after an arbitration award has been issued, this is the step that the employee, not the commission, but the employee is undertaking upon the failure of an employer to comply with the arbitration award. What do we do as the commission upon receipt of this form LRA 7.18? We wait for a period of 14 days from the date of receipt. There are good reasons for this. Those reasons are both financial and also to allow the other party to, if it is a default arbitration award that has been issued, it allows them an opportunity to file a rescission application. The professionals will recall that the Labour Court has made a pronouncement on this one, that where a rescission application has been filed by an employer, irrespective of what stage the enforcement process is, we are obliged as the Commission to deal with the rescission application. Now, the reason why this is crucial for us is if an employer becomes aware before the 7.18 form is processed, we as the Commission will then save money. It is important because we are using a grant which is allocated to us by the Department of Employment and Labor, whereas the Commission as well, if we can save money, it would assist us. The professionals would know that it is common knowledge that the finances of the Commission, especially now, are not in a very good state, and it has had a huge effect on our operations. It is important to note that in this enforcement process, we are not a party as the Commission. The employee remains the party. The CCMA is responsible for payment and it remains a non-party. Now, in terms of the initial instruction, once the application made by an employee has been processed, the initial instruction that goes out to the sheriff is that of attachment. Attach, do not execute. That follows later if the employee wishes to proceed further. That is then that the CCMA would engage the sheriff in terms of the processes that follow after the process of attachment. You would note that our letter to the sheriffs has recently been updated. It is at the back end of, or towards the back end of 2020 that this was updated. This again says to us, we have picked up a trend as the commission that upon the sheriff knocking at the employer's door, the employer would in some cases say, look, I was not aware of this arbitration award. Either a rescission application follows at that stage, which we are obliged to accommodate. And also the employer might say, look, let me rather comply instead of filing a rescission application. So the initial instruction and the gap in between give us space in order to deal with whatever process or application that might come in between. This is our enforcement sheet, which is widely available. You can find it on our website. It offers guidance in terms of what we do and what is expected of the commission by the profession and what is expected of employees. Now, what does the CCMA pay for, Chair? The CCMA in respect of enforcements pays for all reasonable costs in terms of the tariffs of fees. Those, amongst others, include traveling costs, servicing of documents, attachments, execution, storage, advertising, up to the point of sale. Here is what we see as areas that need attention in our relationship. Although we do not have an MOU with the board, I am glad, Chair, to say the relationship, at least between us, from a national office point of view as the department, especially under the leadership of our National Senior Commissioner, Mr. Maria Skotze, is a good relationship. However, there are areas of improvement, especially at an operational level. On the issue of advertising, as the commission, we are saying to the profession, we lack resources. It is preferable that sheriffs cover this part and the CCMA pays for it. We have a very small legal department, which is servicing all 9 provinces and doing a whole lot of things. And believe you me, it does not have a staff complement of more than 5 employees. We also request assistance because there are still challenges in terms of opening of accounts for the CCMA. In this regard, assistance of the board and the associations in unblocking this blockage where payments would be requested from the CCMA upfront. Remember, we are dealing with the vulnerable employees here. When we are referring to the employees earning below the threshold, they will not have money to pay a deposit upfront, and also as a public entity, there are limitations in terms of us paying a deposit for a service that has not yet been rendered. Opening of accounts assists us as the commission to deal with this issue and ensure that service delivery is not hampered. We also see as another area of improvement, communication between the sheriffs and the CCMA, especially where there are interpleaders. You will recall that our hands are tied. We're not a court of law, and we neither have resources when it comes to issues of interpleaders. What we simply say to employees is, okay, the sheriff has communicated this to us. Sorry, we cannot assist you. And that is where, as you will see in my next slide, we see the role of Legal Aid South Africa in assisting us in unblocking this, but we need the assistance of the sheriffs as well. We try our utmost best to explain to the employees what the process entails, but if that communication could also come from the sheriffs as well. Sheriffs are also encouraged to recover the costs from the sale, and the CCMA should be the last resort. We, however, will cover those costs if the sheriff could not recover those costs. You find here in some instances, some of the parties, some employers would approach the sheriff and say, I am prepared to comply with the arbitration award and pay the employee this amount. Now, this is when the process has already been initiated. Now, what we encourage the sheriffs to do is to say, here are the costs of the sheriff's employer. Let's include those in that process. And if it becomes complicated and makes things not easy for the sheriff, as the commission, we would cover those, but we should not, in these circumstances, become the first point of call in terms of those costs. Coming to the role of Legal Aid South Africa in the process, anything during the enforcement process that requires summons or papers to be drawn. Remember, I said, as the commission, our hands are tied. We simply say to the employees, sorry, we cannot assist. And we also do not pay for this. That is where we see the role of Legal Aid South Africa. Applications that have to be brought to whichever court that has jurisdiction to attach banking accounts. We are not involved in these ones, and we also do not pay for those. We are in a process of discussing these with Legal Aid South Africa colleagues. However, these discussions are at an infancy stage. I am glad, though, to say it has cleared the discussions in terms of the amendments to their regulations have cleared board level within Legal Aid South Africa, and we are made to believe as the commission that these are now within the Department of Justice, and from there they will have to be referred to the two houses in Parliament. Legal Aid South Africa, what we have found in our engagements with them is that they basically had no budget to cover civil cases, except it was in exceptional circumstances. Those exceptional circumstances, amongst others, would include cases that were deemed to be cases of national importance, which they would take up together with their partners. However, we still refer employees where there are blockages in the system to Legal Aid South Africa. They would then make an assessment on each and every case and decide if the case is one where they can assist an employee. You would also note, or if you're not aware, please be aware that their means test as well is also far lower than the CCMA means test. Theirs, as at the last discussion that we had with them, was a household earning around 7,000 rands per annum, and you can compare that to the earnings threshold that is used by the CCMA for assistance, and already you can see the huge difference there. Now, when it comes to the process of reconciliation and processing of invoices, we, as the commission, request of the sheriffs to submit statements on a monthly basis, remittances to be sent to the sheriffs after payments have been processed. Upon receipt of remittances, we request of the sheriffs to submit updated statements, sheriffs to submit invoices as and when services or the service is rendered. We have the following personnel within the institution who would be the first point of call where there are blockages in terms of the processing and of invoices and in terms of the delay in paying. Let me hasten to add that as the commission, we try by all means to pay our accounts within 30 days, and where there has been a failure, we have systems in place to deal with those. We have provincial senior commissioners, which are the most senior managers within our 8 provinces. When I say 8 provinces, we as the commission, in terms of our demarcations, have incorporated the Northern Cape province into the Free State that makes up one province for operational purposes. But that office has its own regional senior commissioner. So the Northern Cape is not a province for our operational purposes. It is a region that has been combined into the Free State. So we have one head for the 2 provinces. We have various regional commissioners and senior commissioners who should be the first point of call where there are challenges in terms of payments of invoices. I also know that the profession or the sheriffs deal directly in most cases with our accounts administrators, who are also very helpful, as they are the ones who receive these invoices first before they are processed by the heads of provinces and regions. Chair, this would bring me to the end of a short presentation, I hope, from the Commission. I would be in a position to take any questions and comments from the profession. Thank you.
Thank you, Mr. Manshula, for this very informative presentation. I must say I've got a whole line of questions for you, so I hope you've got a bottle of water, or you do have a bottle of water with you. I know you addressed the issue of interpleader summonses, and I did hear you say that CCMA will not take responsibility for those, for the issuing of these summonses, but I have around 8 or 9 queries regarding the interpleader summons, sheriffs wanting to know where to from there if the sheriff is left in a situation wherein the plaintiff is with him and wanting to know what is the next step that has to follow when a third-party claim is placed, issued for over the attachment of the goods. What does the sheriff do? Some of the sheriffs state here on these questions that their local courts, magistrates court, would not set the matter down for hearing. They want to know what is the solution. Before you answer, I want to give you one more. This sheriff says that the application for rescission and appeals, the outcome of these cases are never communicated to the sheriff, which leaves his file unattended to or not closed. If you can answer those 2 in the meantime.
Thank you. Let me start with the easy one, which is the last question. We owe it to the sheriffs as the commission, where there has been an application for rescission, to advise the sheriff of the outcome of the rescission application and explain further to the employee what the effect of the rescission outcome. Let's say the arbitration award has been set aside. It is our duty to explain that to the employee. This is a point that I will make note of, and we will take back to our regional and provincial managers, and so that communication can be improved in this regard. And we would also call upon the sheriffs to assist us where there has been an application for rescission and you have not heard any communication from the commission. Regional managers, provincial managers should be contacted. I will recall last year that we shared the details of the provincial heads with the board. Those can be shared or distributed to the members of the profession, and where there are bottlenecks or there is still no response, as the national office those can be sent to our department. We will definitely make a follow-up. It is unacceptable that there would be no communication from the Commission on the outcome of a rescission application. It is in the interest, one, of service delivery, and it is in the interest of everyone that is involved in the process. Coming back to the interpleader question, where there is such an application, we request of the sheriffs to communicate with us. The reason why we request this to be communicated with us is we have a duty to explain to the applicants what we can do and what we cannot do. In this case, what we say to the employees is the following. We, one, do not have funds to pay for interpleader summonses. That's number one. Two, we do not get involved. To put it bluntly, Chair, you are on your own. However, we can refer you to our partners. We have various partners who may assist. We'll say Legal Aid South Africa. We'll say Legal Resources Center, with whom we have an MOU. We will say try the pro bono office at the various labor courts in terms of the SASLO project. We will then say to the employee, if within a month of this interpleader issue having come up, no update has been given to the CCMA. In order for us to save costs, we will communicate with the sheriff for the sheriff to release the goods, and the process can start afresh at a later stage once this issue has been resolved. Because what we've picked up as an institution is we would be shocked months later when we receive a huge bill from a sheriff who says, I've kept these goods in storage in some cases for up to 12 months. And that for us points to a breakdown of communication and not understanding what the role of the Commission is when it comes to interpleaders. Thank you, Chair.
Thank you, Mr. Machule. I have another question here. Mrs. Withers, I need to clarify, or I need clarity on whether it is necessary with one sheriff to open multiple accounts for all the different CCMA offices across the country. It will be impossible to offset payments if this is the case. I addressed this issue in 2019 and never received confirmation from the Cape Town branch of the CCMA. I want to read one more related to accounts. We don't have much time, but let me try and squeeze in this one. Tabasile, CCMA paid my money into the wrong account, the former sheriff. When asked to sort it out, they said it's not their fault. Yet account number is always highlighted on the statement. If you want to address those two there, Mr. Machule.
Thank you, Chair. I am not alone. I have a team. This relates to directly our finance department. I'm not sure what can be done. I have my colleague Maputi, who's from our national office dealing with these issues. She can give us guidance on this, as was discussed that she and Ms. Straw would chip in where necessary. I don't know if we can facilitate that.
We would appreciate that. We would really appreciate that. Another question relates to the upfront payment of service providers. The sheriff says that he hears you very loud and clear saying that sheriffs must try and do the work and then recover the money. But the difficulty is that service providers like locksmiths and towing and external service providers of that nature require their money upfront in certain areas. And how does he outlay this money and wait for 30 days or 90 days or even 120 days for his money from the CCMA?
Thank you.
if you want to answer that.
That is also noted, Chair. It will be addressed together with the other two questions by my colleague from Finance.
Okay, a very important question that's come up, or rather a query. CCMA phones are always on voicemail when you want to do any inquiry. It becomes difficult at that time to assist the plaintiffs. How can you assist?
Let me offer a solution. Where there is such a problem, please contact me at the national office. I will request that from the board, that emails are sent to myself and to the provincial heads. We will make sure that those queries are attended to as soon as possible.
Okay, thank you. Last question here I'm going to take on this presentation. The sheriff says that he pleads to the CCMA to understand the sheriff's role in the process so that the work can be, or the task can be achieved much more easier. And obviously, sheriff's costs plays a big role in him providing his service. He pleads to you to understand the sheriff's role and responsibility in executing your enforcement awards. I have a few more, but it's all relating to interpleaders, so I'm not going to ask you again. You've given us an explanation. I just want to read this last one. Okay, this sheriff says that a number of these issues have been raised to the CCMA on numerous occasions since 2018, and they have not received proper answers to these questions. So she pleads to you to obviously look into the matter and obviously provide guidance.
Okay. In terms of Chair, issues that have been raised, which relates specifically to payments of accounts, I will give a general answer. We last year, if I recall, there was communication from the board to say the delay in the payment of sheriff's accounts still continues, and what we requested as the national office was kindly provide us with details. We will ensure that we make a follow-up on those specific account queries where there are sheriffs who still are saying they have long overdue accounts with the commission. So my plea and request is, when these queries are made, especially to the national office, let us be provided with as much detail as we possibly can. We will definitely make a follow-up with the relevant provincial or regional office and ensure that the issue is resolved.
Thank you, Mr. Manchula. I'm going to take the last query now. This sheriff, Mrs. Mabato, says that she's been trying in vain to get somebody to assist her in the Benoni and Furirikung area. If it's possible for you to give a person's name that they can contact, because for the past 18 months, they've been battling to serve the unattended documents that they inherited from the outgoing sheriff. And they are battling to get payment from your department so that they can continue with the work. I don't know whether you are at liberty to give a contact number or whether you can share your details with sheriffs so that they can contact you. I know they will flood you, but if there's a way that you can give us some numbers before you go. Thank you, Mr.
I will share these details. I will provide my email address together with the email addresses of the regional senior commissioners, both in Benoni and in Vereeniging. Would it be in order, Chair, if those are forwarded to the board?
Yes, that will be fine. The board will then direct or forward to the respective sheriffs. Mr. Manchula, I really want to thank you on behalf of the South African Board for Sheriffs and the profession at large, especially the training team, for accepting our invite to come here today and highlight to us your challenges and obviously our challenges as well. It seems like both our departments have challenges with these amendments, and we're hoping to further engage you and find solutions to our various problems and difficulties that we experience. But once again, on behalf of the board, I want to thank you for participating in this webinar, and we will keep in touch with you going forward so that we can further discuss the many other questions that I didn't ask you or raise with you that came through today. Thank you, Mr. Machupa.
Chair, we appreciate the opportunity as the Commission. The three questions that rest within the Finance Department, I will request my colleague that she perhaps puts responses in writing and will forward those to the board, if that is in order with you.
That is in order, Mr. Machupa. We'd appreciate the response in that manner. Thank you for your time.
Thank you, Chair.
Thank you very much. I'm hoping that colleagues on the ground are getting some positive feedback from us, and we're hoping that further communication and engagement with the various stakeholders that already addressed us is enhanced for the benefit of the profession. We have a very important stakeholder who's going to address us now, Mr. Chawe from the State Attorney's Office. Mr. Chawe will explain to us the processes and procedures followed by the State Attorney, and obviously try and assist us in addressing certain queries that we have going forward. I now hand you over to Mr. Chawe.
Good day, Sam. Thank you so much for being invited in this very important discussions, which really, it's one of the sticky points sometimes when you work with a stakeholder and you don't understand each other's operations. And I'm not taking it for granted that the sheriffs don't understand our operations. They do understand our operations, but there are certain instances where you will find that we have some issues which remain unresolved, or when they are resolved very late. And I'm sure that as the convener of this particular discussion has actually put on the relevant issues which the sheriffs would like the state attorney to air their views on. And let me just say from the beginning, Chairperson and the coordinators, that some of the issues which are being raised, I've seen the similarities of the same with my colleagues who have just spoken, from Mr. Malema to my colleagues in the Small Claims Court, and now my other colleague also at the CCMA. These seems to be common cases, and I hope that some of the questions which were posed to them and also answered, they might also give a particular assistance in what will follow after my presentation. Let me apologize to all my colleagues and all the other panelists that due to the challenges I have with this electronic things, I might not have prepared a proper presentation. But maybe let me start here and say that the state attorney as we know it has actually changed a bit, in that the state attorneys are independent on themselves throughout the province. And each and every state attorney is a state attorney on its own right, meaning that the state attorney Johannesburg, for instance, and the state attorney Pretoria, they are state attorneys standalones. In the past, there was, in terms of the old act, there was only one state attorney which was stationed in Pretoria, and then other branches of the state attorney throughout the country. But the amendment has been brought through the amendment which came into effect last February in terms of the State Attorneys Act. It remains the same number, but it has been amended by the Act in 2014. So each and every state attorney now stand on its own, but we have, as the state attorneys, an apex authority. And this apex authority also came into being through the amendment of the State Attorneys Act. And the apex authority, as we speak, it's a Solicitor General. I will suggest that all of you colleagues and panelists, you will now recognize now and then that there is a speak or there's talk of the Solicitor General. Now the Solicitor General is the apex authority of all the state attorneys in South Africa. And this particular individual, he is actually the executive, if I might use the word, the executive of the state attorney, and reports directly to the minister. So he or she, as for now, it's a he, whose appointment has been started last year, March 2020, and it's only for 2 years. So this particular Solicitor General for now is Mr. Fezisani Pandelani, who is stationed in Pretoria and in the same building where I am, meaning the Salu building in Thabo Sehume Street. So that's where we are controlled, if I might say so. That's where the state attorneys are controlled, and the power base is within this particular individual, the Solicitor General. I'm so sorry that I digressed from my mandate, but I was just trying to make that point clear, that that's what the amendment has brought in as far as the state attorneys are concerned. Now, the facilitator, now going back to what I'm supposed to do and my assignment of today, I've realized that I've been asked, among other issues, to address the issue of prescription, which are, or prescribing matters, which are sent to the sheriff for him or her to assist us to serve. In general, everybody will know that most of the deaths, I will say most because there are certain exceptions, most of the deaths do prescribe within 3 years. There are instances where, for instance, especially for the state attorney, my colleagues who are sheriffs will tell you that the state attorney is one of the headaches, if I might say so. I'm not trying to mean it in a bad way, but in a way that it describes the feeling which might be espoused by some of our colleagues who are sheriffs, that the state attorney might be a headache in as far as bringing documents on time, especially those which are sounding in money, which need to be collected for our present government. And these colleagues, it's not necessarily that one can use a particular excuse and say, no, it's because our attorneys don't know how to draft and so on and so on. The problem starts, as if I might say so, it starts from when the clients, because as attorneys, we get instructions from clients, that some of our clients have the tendency to sit almost 2.5 years with claims which they were supposed to have brought to the state attorney on time, and they wait until their internal legal people have written letters of demand to the debtors, and the debtors do not respond, and then they end up bringing this particular documents to us on a very late stage. Now you might find that when these matters arrive at the state attorney, we are left sometimes with around 3 weeks within which to issue these summonses and recover these debts, which are actually the public payers, monies which are owed to me and you, colleagues, facilitator and chairperson, these are debts which are owed to us. So the unfortunate problem is that once these come at this late stage, we end up now passing the buck, so to say, to the sheriff and say, Sheriff, you know what? I've just received this thing last week. I was only able to consult with my client last Saturday or Sunday or whenever. I'm finished with my pleadings, and therefore here is a complete pleading. Please go and serve. Now the poor sheriff has only maybe 2 hours or 3 hours to do so, because I'm aware also that our messenger service as the state attorney, sometimes it's very low to react. You might find that a summons has been given to a messenger at 9 o'clock in the morning, but it only arrives at the sheriff at 2 o'clock in the afternoon. I mean, it's late already at the time, especially in areas like Gauteng. You'll find that the sheriff now will have to drive through or the deputy sheriff has to drive through the traffic and try to serve the documents at the time. So it is a big problem for us. And we are hoping that in the stakeholder meetings which we are having with our clients, especially the clients who have a high amount of debt, like for instance, departments like Department of Health, the Ministry of Police, the SANDF, and so on, colleagues, including the police themselves. We have these problems that they always bring things late to us, but we are engaging them, trying to sensitize them, the problems which they put us on, and also the pressure which we put onto the sheriff and all that problem. But having said that, coordinator and the facilitator, it's that in the event that, for instance, we do send this particular late referrals of service of prescribing matters to the sheriff, what I will suggest is that it must be that there is a specific letter from the state attorney's office, which number one, confirms the date of the prescription. When is the matter going to prescribe? At least the date on which the service has to be done. And I've seen, I don't know whether it's relevant, coordinator and the facilitator, but there's also a sentence which we usually put, wherein we make an undertaking that the agency service or the agent service fee, if it's applicable, will be paid by the state attorney. And further that, in that letter, we confirm the address of service, because although the sheriff, yes, most of our colleagues who are sheriffs, are maybe all, if I'm not mistaken, are legally learned people, but it will be really unfair for the state attorney or any other party to that matter, either being from the CCMA, as my colleagues have said, or from the small claims court, or even from where Mr. Malema sits, to expect the sheriff now to go through our papers and read that when was the debt due, when is it prescribing, where must it be served, when is the last date. I don't think that will be proper. So a covering letter for me makes sense with mentioning all those crucial points which I have mentioned. But I am aware, facilitator, that this has caused a lot of problems in as far as prescribing matters are concerned. And I would suggest that maybe in the stakeholder meetings, which I very much support, as stated by Mr. Malema, of the PEEC, the DEC, that maybe the sheriffs as a board, the sheriff as a board, must attend this meeting and even educate us as their consumer of their services, to tell us, look, the best way of us receiving agent matters like this, I'm not including agent applications here because they are nature of their own, but I'm talking about something which we can do something about, which are prescribing debts, that maybe the sheriffs during those meetings must at least educate us and say, look, what is the latest time when within which these particular prescribing matters might be brought? I think that will be very important, and it will make sure that offices like the state attorney will be able to take matters forward. And I will suggest then, facilitator, that one way or another, I have covered another issue which has been raised for me, which is accurate service address and contact numbers of those who need to be served. I'm aware that in the government, especially state departments, have this particular grave problem where they tend to sue those who have left their employment, especially for salary overpayments, for people who owe the hospital, for instance, those who have studied for loans in government through assistance by our money, because they are using the public purse to study. Some of them are good doctors, which I do appreciate. Some are nurses, some are engineers, some are pilots, and so on. So some of these, you'll find that there's contracts which are signed by these departments for training, and they leave without paying. So you'll find that this particular address are some of them 2 years old, 1 year old. So by the time we issue summons, these persons have left these particular addresses. Now our colleagues from the sheriff's board struggle to find addresses. They go there, and I'm aware how, I don't know whether should I say our community has changed nowadays. Sheriffs are not getting a very good reception when you introduce yourself as a sheriff. So the sheriff goes and knocks on someone's door who now occupies this building, and is met by some other person. Let me cough a bit, colleagues. Who is not that friendly to the sheriff, and will say, no, I'm not Mr. So-and-so, Mr. So-and-so, I don't even know him. So what is important for us, which we are trying to address as the state attorney, is that before we issue summons, we would like the client to confirm in writing, other than the address which has been stated on the contract, which was signed by the former employee. There must be a letter confirming that we have checked the address, current address of this particular defendant, and he's now staying at this address and this address. So we are hoping that this will assist our colleagues in as sheriffs to be able to serve our documents on time and not to struggle, including facilitator, that the correct numbers has to be given. This is very important because in complexes nowadays, you come to a complex and you don't know where to start. And even these security guards, which we so love, sometimes have their own issues to say, you can't get in here because you must first phone this person and so on and so on. So it is also very important from the attorney side also to have contact numbers of the defendants or respondents, as the case may be. Now, one other issue which I would like to, I know that facilitator, the sheriffs are not here, or the board as such is not here to be lectured about the amendments and how service needs to be done. But can I just point out to only two of issues which I want to raise with our learned colleagues from the side of the sheriffs. In terms of the amendments of the State Liability Act, if I'm not mistaken, and these amendments have been brought. This particular amendments, I will maybe just in few minutes inform the panelists about the specific sections. These sections say, in terms of this State Liability Act, that as soon as a process has been served on a state department, within 5 days of its service, it must be served on the state attorney which has jurisdiction in the area where the client is. So I must apologize that I know that this particular issue is not at all the duty of the sheriff to tell the attorney what to do when they send pleadings to the sheriff, or the initial pleadings to the sheriff to serve. But it's a very important issue because it creates a lot of problems, but at least not for the sheriff, but in court, where you'll find that they serve the Minister of Justice in Pretoria, and they only give the sheriff instruction to serve the minister. But they forget that in terms of this particular amendment, the state attorney in whose jurisdiction the Minister of Justice is, and in this case it will be State Attorney Pretoria, need to be served with the same pleadings within 5 days. So the service can only be completed once there is service, number one, on the defendant, which is the client department, and number two, on the office of the state attorney in that jurisdiction. And while I'm addressing this facilitator, you will find that the state attorney has also opened offices, I will suggest now, in most of the provinces, including the office which didn't have the state attorney, the province of Mpumalanga. There is now a state attorney in Mbombela, or what used to be called Nelspruit. There is a sheriff there. I'm sorry, there's a the office of the state attorney in that particular province. So most of the matters where you serve the state attorney, let's say, for instance, you are going to serve the police, the provincial commissioner of police in Nelspruit. So you are welcome to also serve the state attorney in Mbombela. I'm just making this observation, not necessarily that I'm insisting that this must be done, because it is not the sheriff's duty to start running around and educating attorneys, but it's good that it must have. So this particular amendment, or the sections I'm quoting, facilitator, it's in terms of Act 40 of 2002, and I was specifically, I'm sorry, it's the State Liability Act, Act 20 of 1957. the State Liability Act 20 of 1957, and I was looking at section 2 of this particular act. And one act which I also want to refer to is it's a very long title of an act, Institution of Legal Proceedings Against Certain Organs of State, but it's just Act 40 of 2002. And here it's just, I want to mention one thing, facilitator, and this is section 4 of this particular act, and it reads as thus: any process by which legal proceeding contemplated are to be instituted must be issued by the court in whose area of jurisdiction the cause of action arose. So it means then that even if the Minister of Justice is in Pretoria, you cannot issue a summons in Pretoria if a motor vehicle accident of this minister took place in Mbombela. You must issue that proceeding in Mbombela, although you might serve in Pretoria. But this, as I say, my colleagues, it has nothing to do with the sheriffs, but it's just a point which one needs to consider. So moving on then to a very, very important issue, the payment of sheriff's account facilitator. This, I must say, is one of the most problematic issues which we have in the offices of the state attorney. And I will suggest that it's across the country. But speaking for the state attorney Pretoria, I know exactly that we will be having a lot of problems where the colleagues of ours from the board have a serious problem of fees which have been outstanding, some of them for years. And I'm not trying to exaggerate here, a facilitator. Some of them are owed for years. And I cannot start even to say what might be the problems here, because every time you ask a colleague, why are you not paying the sheriff? Then you will be running around, or she will be running around giving 10,000 reasons and so on and so on. But what is important is that in this regard, one has to make sure that, and I'm asking this from my colleagues from the board and even the sheriffs as such, that it is very important that every time a process has been sent to the sheriff for service, there must be a name of the attorney and the reference number of that attorney. I know that maybe someone will say even the case number, yes, it's important, but what is very important is that the document must contain at least the name of the attorney and also the reference number of this particular attorney. Because as soon as the sheriff has served a process and a return of service and the invoice of the sheriff has been sent to the state attorney, it is important that we identify the attorney and the file reference number so that we can immediately take this particular invoice to the attorney to account and pay the sheriff invoices. And as Mr. Malema said, and my other colleagues have said, the Department of Justice and any other department in general, as Mr. Malema have said, the Treasury is insisting that all service providers must be paid within 30 days. And in effect, Mr. Malema, I know that we have spoken already, my colleague, in one of the meetings which we had with the minister is advocating for consequent management against those who are failing to pay within 30 days. So I will suggest that as time goes, we will be forced, including some actions maybe against some of us who are not paying within 30 days, that we must explain ourselves, otherwise consequences may follow. But I'm pleading with all my colleagues at the board or the sheriffs as such, that as soon as the matters have served, get the name of the attorneys, get the reference numbers of these particular matters and send it directly to the office which you know that needs to pay you. The state attorney would wish also to add its voice to what my colleagues from the CCMA and from Mr. Malema, that maybe this thing of manual payment must see its last days, because that's one of the most cumbersome processes what one could have, because some of the attorneys will print an invoice, file it or misfile it, and it will never be paid for years and years until such time that my colleagues from the board and the sheriff as such will embark on a strategy, which is a defense mechanism, although sometimes it hurts us, but it does help, not from my side, but maybe from the sheriff's side, who said, look, the state attorney's account has been closed because you are not paying. That's a very, very bitter pill to swallow, but a necessary one maybe from the side of the sheriff, so that they can force the state attorney to settle their invoices, and so that, as the facilitator have said, they need to make a turnover and make sure that their businesses continue as a going concern. Otherwise, we'll run you down. So the sooner, Mr. Malema and my other colleagues, we get the systems running to move to an electronic system where we can file these documents and the sheriff's invoices, the better. So we are hoping that this will be of assistance. So, and I'm going to ride on the back of Mr. Malema in as far the reconciliation of sheriff's invoices. I think it's very important that when the sheriff's reconciliation statements are sent, they must also bear what Mr. Malema so much emphasized, that there must be maybe for Mr. Malema, it might be a case number, but for the state attorney, it must at least be a reference number of the attorney or the name of the attorney where applicable and the amount, so that we must immediately look at who is handling the file and under which reference number, so that we must be able to check as quick as possible to do so and attend to these. I must say, in the office of the state attorney facilitator, we have one lady who really has been appointed and dedicated to looking at the sheriff's invoices. And we have this lady's name. I don't know whether it will be necessary to give the name, but maybe during the question and answer, I will be given that opportunity if it's necessary. Because she said to me, it's not a problem that her email address be shared with the sheriff so that they can be able to follow up on their invoices. And she's really happy to assist on that one. And now on the issue of handling of queries, facilitator, it is very important to mention the following issue, is that the complaint system, the way it works, I know that is not necessarily a complaint, but it's a query. The first person of contact is the attorney himself, if his reference number or the name and the contact number is known, including the email address. That's the first point of contact. If that particular person doesn't respond, the office of the state attorney is structured that an attorney reports to a deputy state attorney. Then that deputy state attorney, where known, must be contacted. But I don't want to make really an issue of query handling a cumbersome issue. Each and every state attorney has the head of office. And these heads of office may be contacted. I hope that as time goes, we'll be able to share, or I think in some website, the Department of Justice has also names of heads of offices. These particular officials and colleagues of my senior colleagues of mine are entitled to receive queries from any of our service providers, which will include sheriffs, to make sure that they get their queries resolved as soon as possible. If really the cumbersome process of going from one person to another might delay the matter, so that we go there directly. And I know that if it comes to a push and matters are not going as well as they should go, then the office of the Solicitor General is there to address issues like this. But I don't think the office of the Solicitor General will just be engaged just for an issue which can be solved on the run of the mill. It will be issues really where the attorney is, or the office, the specific office of the state attorney is notoriously not paying invoices. Like I've mentioned colleagues, I'm aware that the state attorney Pretoria, among others, I don't want to speak about my colleagues in other provinces or in other towns, but I know that the state attorneys Pretoria do have problems in some of the sheriff's invoices. There are many reasons which one can state, but for the purpose of this particular discussion, my colleagues, unless I'm asked to do that, it's not necessary. What is important is that the state attorney must pay his dues within the 30-day period. And if it's not done, any of our service providers, including the sheriffs, must take this point on so that we will be able to do it. So thank you so much, Mr. Facilitator. I really appreciate. I will wait for the questions. Thank you so much.
Thank you, Mr. Chawat. A very informative talk, I must say. It's the very first time the profession is engaging with the state attorney at this level. So your discussion today and the points you raised is very valid and most welcoming. I have a few questions for you. The Sheriff of Mbombela raised the issue of the prescription, saying that state attorneys generally send or forward the applications or summonses virtually on the 31st of December, and it prescribes on the very same day. It makes it difficult for the sheriff to serve these documents because, as like any other business, sheriffs also shut down in that period. So I think the important aspect that she wanted me to bring to your attention is that should this document not be served, there are financial consequences for the sheriff, in that the sheriff is liable for the claim that is due on the summons if he fails to serve. Therefore, she wanted me to impress upon the fact that the state attorney should, as far as possible, send these summonses at least 15 days prior to the prescription date to the sheriff, and so that this document can be timeously served, and obviously there's no claims for damages brought against any party. I think the very important aspect as well is the fact that sheriffs operate in all parts of the country, in different jurisdictions, and we are concerned about our rural colleagues, sheriffs who work in the rural towns, wherein they have to travel long distances to serve these documents. And if your matter reaches them at 4 o'clock in the afternoon, it makes it very difficult to serve. I'm glad to hear you commit to ensuring that your departments forward a constructive letter with these documents so that the sheriff is guided and protected to a large extent. I have a few questions for you, Mr. Chawe. This sheriff says, thank you for the good work that the state attorney does, but the problem comes when payment needs to be effected on the warrants for costs. They undertake to effect the payment, but then 2 to 3 months down the line, the payment is not yet been authorized. We as the sheriff been crucified by the attorneys for not executing their mandate. In other words, when documents are served on the state attorney for payment, and the state attorney pays the capital amount, excluding the costs. And this is where the sheriff is now hounded by his instructing attorney. This sheriff says, how do I get compensated? I have outstanding amounts for the past 3 years with the state attorney. One more related to accounts. This sheriff says, in fact, it's a compliment. As much as certain government officers, state attorneys' offices are giving problems when it comes to payment of invoices, we would like to give a thumbs up for the state attorney in Johannesburg, Representative Mr. Mali Madlope. The sheriff says she's getting good service from the state attorney's office. Mr. Chawe, you want to respond? Are you there, sir?
Thank you so much, facilitator. Yes, I'm here, sir. Can you hear me?
Yes, I can.
Yes, thank you so much. Thank you so much. Yes, I do understand, and that's why I even acknowledge, although acknowledgement doesn't mean a good thing, it's just that you acknowledge, but what is important is that these payments should be done. And I do take what my colleague in Mbombela is saying, that at least 15 days must be done. It will be really very good for a sheriff to get. But as I've said, it does happen that we only get instructions 3 days before. And that's why I say this is actually a problem. But thank you so much for that comment. One needs to really attend to it. And in as far as the payment of costs, there has been a lot of problems which emanates from the client side. You'll find that the state attorney did receive tax costs from the client, or from the courts, because courts will immediately do a text bill of costs, give it to the attorney, and the state attorney who has attended, or even the cost consultant of that particular state attorney. The biggest problem comes, Mr. Facilitator, that you'll find that there is no specific instruction from the client to allow us to pay that particular account. So that's where the problems are. But as I've said, we are working with the clients that they must, from the onset, when they send the brief to the state attorney, all instructions letters must be there which authorizes the state attorney to handle the matter, pay for the sheriff, and even pay for the advocates, any other thing which inherent to the running of the matter. So we are trying our best to get these things done. And with regards to the colleague of ours whose invoice have been outstanding for 3 years, it's really a shame, I must say, colleagues. You know, it's so difficult that I think myself, if you were to stay 1 month without your salary, I don't know what will happen in my life. And now imagine a person who has not been paid for 3 years. And I'm going to ask this particular colleague of mine to please, if it's the State Attorney Pretoria, send those invoices in a package to the State Attorney. I can maybe say that my email address, if it's the State Attorney Pretoria, my email address is ichowe@justice.gov.za. Send all those invoices to me. I will see if I can't at least communicate with my colleagues who are owing these invoices and impress upon them to quickly attend to these invoices. As I've said, my email address is ichowe@justice.gov.za. I think that's bad enough, my colleague. And I'm aware that my colleagues in Johannesburg, they're doing a very good job. And I'm going to give this message over to my colleague in Johannesburg, the head of the office there, Ms. Mobeng. Thank you so much.
Thank you, Ms. Chawe. On behalf of the sheriff's profession and the South African Board for Sheriffs, I want to thank you for acceding to our invite. As I said, it's the very first engagement the profession is having with the state attorney. I heard you at the onset that mentioning that every state attorney's office operates independently. So I'm hoping that walking away from this discussion today, you would filter this discussion to the various heads of departments in the various provinces, so that there is a unified approach to the discussion and the resolutions or suggestions made by the sheriff's profession. I'm hoping that we can find solutions in the various state attorneys' offices going from this discussion. As I said, on behalf of the South African Board for Sheriffs, I want to thank you for attending to this webinar today and giving us insight into the way the State Attorney's Office operates. Thank you, sir.
I do appreciate my colleagues, and thank you so much. And I will request that the further coordination of meetings of this nature, which must happen regularly, the Office of the Solicitor General needs to be immediately informed so that we can control it from the apex. Thank you so much. I do appreciate it.
Thank you, sir. Thank you. Colleagues, we've now had the final presentation or discussion topic, but it seems like we've addressed this matter extensively with Mr. Malema. But I want to thank Mr. Swaneshwari Pillai, the taxing master of the Pietermaritzburg Magistrates Court, for acceding to our invite at the very last minute, in fact, just late yesterday, because our initial invited guest could not make it today. I'm going to now hand you over to Mrs. Pillai to give us a talk on taxation. Mrs. Pillai.
Hi. I'm Vaneshri. I'm one of the registrars that taxes bills at the Durban High Court. Basically, when all bills arrive for us to tax, we basically look at the following aspects on the bill. The bill of costs must obviously be taxed in accordance with any court orders or agreements for services actually rendered by legal practitioners. When a court awards costs to a litigant, it does so to indemnify that litigant for the expenses which it incurred in either having to initiate or defend the litigation. The ordering of costs that us as taxing masters of the High Courts usually look at is Uniform Rule 70 of the Uniform Rules of Court, which us as taxing masters have to comply with, and our discretion is also centered around the Uniform Rules of Court. The two main cost awards that are found in the rules are basically our party and party costs and our attorney-client costs. And obviously the attorney-client costs have various scales within it, which we have to use our discretion as well when taxing. So us as taxing masters must basically ensure that the bill is taxed in accordance with the uniform rules of court and it is fair and reasonable to both parties. Sheriff's bills, when they generally do appear before a taxing master, there's usually there is a dispute usually with some of the items, which us as taxing masters try to resolve. So that's just basically it from the taxing master's perspective. And I'm not sure if there's any other questions that you might have.
For that, I must apologize. I mentioned that you are from the Magistrates Court in Pietermaritzburg and see you are from the Durban High Court. I must apologize for that error. I do not see any questions from colleagues on the ground, but just to highlight to you our concern that was raised with Mr. Malema, and maybe you can take this forward in your department as well. Concerns by the sheriffs is the fact that taxing masters do not understand sheriff's fees and the formulation of sheriff's fees, which is detrimental to their winning the taxation or being successful in maintaining their fees. So it's something that taxing masters in your capacity needs to take into account. And we raised the issue earlier on in regards to the jurisdiction when it comes to taxing of sheriff's accounts. But this is an amendment, although it's in the Magistrates Court, not in the High Court, wherein the taxation must take place within the jurisdiction or the court that issued the document. So we're hoping that you can assist us in some way in your environment there to ensure that the taxation takes place within the area of service of the sheriff. I've got one question coming up here. Let me read it to you. Okay, it says here, is it procedurally correct for the one party to the bill to be taxed, have prior discussions on the matter in absence of the other party? I'm presuming the sheriff talking about the attorney having discussions with the taxing master without the sheriff being present, or vice versa. Is it procedurally correct?
The thing is, if it's on the opposed taxation roll, if it's enrolled by one of the parties for argument before a taxing master, then it's not procedurally correct. Both parties were supposed to have been present if it was on the opposed roll.
Okay. Thank you very much for that. I don't see any further questions. Just another query or suggestion by the profession is obviously, as you would have heard, being connected to this webinar today, you would have heard a lot of queries or concerns being raised in regards to taxation of sheriff's bills. As you know, the economic situation today forces attorneys to query bills presented to them by the sheriffs. So we are urging you to ensure that you understand Table C Part 2 of the Magistrates Court Act and Rule 68 of the Sheriffs Act in regards to sheriff's fees, so that you are being fair to sheriffs. I think one of the very important aspects that needs to be taken into account by taxing masters is that sheriffs, certain parts of the tariffs is open to the sheriff's discretion in that, especially when he's engaging removal companies and external service providers. So he has some discretion in terms of engaging external service providers. And this is where the query comes in from attorneys. So we impress upon you as taxing masters to ensure that you understand these aspects of the tariffs. I don't see any further questions raised, ma'am. With that, I want to thank you for attending. Just hold on before I let you go. I see there's another one. This sheriff wants to know if the sheriff is asked to tax his bill, it is called upon to tax his bill, isn't it already opposed, or must there be a notice to oppose the bill? Just to clarify.
Usually there is a notice to oppose that is served and then brought to us after it is served with the bill.
All right. The next question, who must approach the court for an account to be taxed if the attorney disputes the account? I guess the sheriff wants to know whether it's the sheriff or the attorney who sets the matter down.
In some instances, we've had the sheriff setting matters down. It can be either party.
Okay. I guess that is in terms of the High Court Act, Rule 68. All right. I don't have any further questions for you, ma'am. Seems like a lot has been addressed on the onset of Mr. Malema. But as you heard, we will then be further engaging your various departments in understanding your responsibilities and further enlightening you on the sheriff's role and our difficulties in being assisted in a fair manner by the various taxing masters. With that, on behalf of the South African Board for Sheriffs, I want to thank you for participating in this webinar today, and I must apologize to you for engaging you at such short notice. I'm sure if we engaged you earlier, you would have given us much more in terms of the rules and in terms of the operation within your courts. But with that, it's been a pleasure talking to you, and on behalf of the board and the profession at large, we want to say thank you, ma'am.
Thank you, Mr. Chairman.
Colleagues, we've now reached the end of the masterclass or webinar. I want to, before I hand over to Mrs. Anna Ralikashla, who is our fellow board member, I want to thank all colleagues for participating in these masterclasses. As the chairperson of the training committee, it gives me great pleasure to see the interest from the profession at large. It indicates that our effort did not go in vain, and it indicates that we are hungry for training and further information and assistance from the board. So I want to really thank colleagues, the associations, deputy sheriffs and staff for participating in these master classes. Before I hand over again, I want to thank the management team of the board, Mr. Van Beek and Mr. Nell, the training manager, and his team for the long hours put into our discussions and in formulating these various master classes. I know a lot of work has been put into this master classes, and also my two colleagues in the training committee, Anna and Andrew Komisi. Thank you very much for your effort. I wanted to do this on a personal level to thank the people that was working with us behind the scenes. I'll now hand you over to Anna for the final vote of thanks.
Good day, everyone. My name is Anna Ralitlaka, Sheriff Polokwane, and Chair of the Board, panelists, fellow board members, members of the Sheriff's profession, support staff, ladies and gentlemen, welcome and good day. It is indeed a pleasure to do the final word and vote of thanks, not only after this intensive and fascinating masterclass of today, but the culmination of a series of visual classes we have had these past few months. This is also the final masterclass of the financial year of the board. The organization of this form of seminar, or more aptly defined as webinar, was not initially on the training agenda of the board. As you are aware, COVID-19 has forced all of us to think radically about communicating in new ways with our constituency, our stakeholders, and the public at large. We are learning ourselves into the new system and trying to get on top of what modern technology can offer us. This is a sharp learning curve and opportunity for sheriffs, staff, the board, and management. We are hopeful to return to our face-to-face interactions, as we are at the end of the day human beings that need social relationships with each other. Though in the same breath, we all know that the world will never be the same. In the foreseeable short to medium term, we will be forced to meet virtually. A range of masterclasses have been facilitated by the Training and Communication Division. The team is getting fully informed about the requirements of such masterclasses to ensure successful implementation. Suffice to say that quite a lot of behind the scenes tasks are required. For example, the drafting of specific inputs by the presenters, drafting quotations to potential providers, logistics of invitations, and the organization of trial runs. I can clearly attest that we are successfully completed the following 4 financial masterclasses, being 1, new tariffs for sheriffs, facilitated by Mr. Alan Morrigan. The aim of the session was to ensure that sheriffs are charging the correct fees and also all fees due to them. Number 2, sheriff software programs facilitated by the different software providers to ensure that sheriffs are using the software that they pay for to help them with their financial administrations. Number 3, debtors management facilitated by Mr. Sensei Grove, meant to assist sheriffs and their staff to approach debt collection in a manner that would assist them to build good relationships with their debtors with the purpose of collecting outstanding fees due to them. 4th, which is today, masterclass, maximizing our income, so eloquently presented by our panelists of today. Invitation to all panelists was to share their side of the civil justice system and to let sheriffs to understand the processes and procedures and to have possible solutions that will assist sheriffs to optimize their income. We are cognizant that our presenters, such as our panelists of today, are under huge pressure to deliver input that is set apart by excellence. Let me hasten to congratulate you regarding today's stimulating and thought-provoking inputs. As sheriffs, we are aware of the challenges you are faced with, and I can assure you that we commit ourselves to work towards closer links and relationships with yourselves. Let me also thank the following: the moderators of this session, Mr. Nkumise and Mr. Morrigan, for an excellent performance, not only during these masterclasses, but also steering the previous visual classes towards robust debate and thoughtful conversations. Thank members of the board whom we rely on for critical feedbacks. The presence and contributions of sheriffs who view the masterclasses as beneficial to their business, personal growth, and excellent service delivery to the public at large. The training staff of the board, under the leadership of their manager, Mr. Nell, and our executive manager, Ms. Judy van Beek. The I-team ensuring the stability of the platform to ensure minimum disruptions in our conversations, and the chair of the Training and Communications Committee, Mr. Alan Morrigan, for guiding the committee in purposeful and strategic direction. Finally, I would like to thank the chair of the board, Mrs. Charmaine Mabuza, for her visionary leadership. We thank you.